This court granted the state's Rule 9 application to address one issue. Did the trial court have jurisdiction to revise its 13th juror ruling at the motion for new trial hearing when the motion for new trial was untimely and the judgments had already become final? Both parties agree the answer to that question is no. The judgments became final on September 19, 2022, 30 days after they were entered, and the defendant's motion for new trial, which was filed 1 week later, was a nullity. Tennessee law is clear that trial courts cannot extend the deadline to file a motion for new trial, and the court did not have jurisdiction to modify the final judgments. That should be the end of this case, Your Honors, but the defendant has argued that the state is stopped from challenging the trial court's order granting the defendant a new trial, citing the exceptional circumstances or estoppel by benefit doctrine that the Tennessee Supreme Court adopted in the Turner decision. That doctrine does not apply here for 3 reasons, which we've explained in our reply brief. First, this is a doctrine that's only applicable in civil cases when a party seeks to set aside a void judgment pursuant to Tennessee Rule of Civil Procedure 60.023. I haven't been able to find a single case where this court's applied the doctrine in a criminal case. The defendant did not cite any in his responsive brief. And furthermore, as I understand the exceptional circumstances doctrine, it only applies when a party is seeking to set aside a final judgment. Here, the trial court's order granting the defendant a new trial was not final, and the state timely sought interlocutory review pursuant to Rule 9 within 30 days after the order was entered, so it wasn't a final judgment. And finally, even if this doctrine could be applied in criminal cases in an interlocutory review posture, it wouldn't apply here because the trial court lacked subject matter jurisdiction to modify the final judgments. In Turner, the court was dealing with a situation where a judgment terminating parental rights was void for lack of personal jurisdiction due to lack of constructive service. So the court, even in Turner, suggested in a footnote that it would not apply the doctrine in a case where there was a judgment that was void for lack of subject matter jurisdiction. The court didn't reach the issue, but it cited other states that have expressly held that. So even if this could be applied in a criminal case, it wouldn't apply here because of the lack of subject matter jurisdiction. And finally, just even taking the defendant's argument on its own terms, there were no exceptional circumstances here that would justify estoppel. First, the state did not manifest an intent to treat the judgment, or the trial court's order rather, as valid after it was entered. We do know that the state did not object at a couple of hearings prior to the entry of the order granting a new trial. But if you read the Turner decision, it talks about a party manifesting an intent to treat the order or the judgment as valid. And here, as soon as the order granting the defendant a new trial was entered, the state, within the time provided by the rules, moved for interlocutory review in the trial court. So it never manifested affirmatively an intent to treat that order as valid at any time after it was entered. And then, relatedly, there's no substantial reliance that the defendant can point to on this order. Whereas in Turner, you had an order terminating parental rights that had been final for 8 years, and one of the parents comes in to try to challenge that for lack of jurisdiction. Here, as soon as the order was entered, the state had 30 days to seek interlocutory review, which is exactly what it did. So the defendant had no reliance interest in the finality of the judgments because they hadn't become final yet. So even taking the defendant's arguments on its own terms, it fails. And lastly, I'll just say that the defendant invokes Rule 36A of the Rules of Appellate Procedure to try to argue that the state has waived this argument. And we've cited a case in our brief where this court has expressly said Rule 36A waiver principles just don't apply when the issue is one of subject matter jurisdiction. If this court has no questions, I'll reserve the remainder of my time for rebuttal. Judge Montgomery?
I've got a procedural question.
Sure.
And of course, obviously, we haven't made a decision yet as to how we're going to proceed, but I was looking at some of the filings that occurred in this case. And you said earlier, I think the original judgments were filed August 19th, and then the trial counsel on September 15th filed a motion to withdraw. And on that same day, the defendant filed a pro se notice of appeal, even though he was still represented by trial counsel.
I believe that was filed in the trial court?
Yes.
The pro se notice? Okay.
Okay, but there was a quoted notice of appeal of the original judgments technically to our court, even though they filed it in the trial court. The question then becomes, because he was still represented, then obviously we've had the discussion about the motion for a new trial was not filed until more than 30 days. If we should make the determination that that there was not jurisdiction, that the trial judge erred in granting a new trial, where would the posture of the case be? Would there still be technically pending a notice of appeal even though it was filed?
No,
Or is it too late? What would your opinion be, or what would the state's opinion be?
So the pro se notice of appeal that was filed in the trial court is a nullity. It just doesn't exist because the defendant was represented by counsel at that time. So I don't think it would retroactively be revived in some way if this court were to rule in our favor. We're just asking the court to reverse the judgment.
So in other words, there wouldn't be an opportunity for appellate review of the trial?
Not through that mechanism. The defendant does have a pending post-conviction petition, and that's been stayed pending this appeal. So if the defendant were to get a delayed appeal through the post-conviction process, then potentially there would be an avenue for appeal.
Okay, thank you. I appreciate it.
But we think the court should.
I mean, I'm not asking, it's not part of the briefing. I was just procedurally, I was trying to think through that. But if there's a stayed post-conviction, okay, all right, thank you.
All right. Thank you, Mr. Gross. All right.
Good afternoon, Your Honors. May it please the Court, Brennan Wingardner on behalf of the appellee, Claude Banner. Judge Montgomery, if I may piggyback right onto that. Our position is that if this court determines that there was no jurisdiction and undoes or vacates the trial court's order, procedurally there is the post-conviction petition that has been stayed. I think another option would be for Mr. Banner to seek a late filed or to file a late filed notice of appeal and ask this court to waive the timeliness in the interest of justice.
I was going to ask, I'm glad you started with that, because that's where, when I heard your question, that's what I was going to ask you when you stood up was, could the defendant not, assuming we get all the way back, so to speak, could the defendant not just file a notice of appeal with a request for us to excuse the timeliness requirement, which the rule clearly allows, and basically start over again on the direct appeal appellate process, still leave the PC stayed, and then proceed as if this never happened, so to speak?
I believe so. And that was obviously, that would have been my alternative argument today, was to ask this court that if the trial court's order is vacated, to include some language in the opinion that this is not, or this is without prejudice to his ability to seek other remedies. Certainly, I think seeking.
Of course, if it's delayed, because it appears that the motion for a new trial was delayed, then the only issue on a direct appeal would be sentencing and sufficiency of the evidence.
That's correct.
Then he would still have potentially post-conviction and then file again to raise all the other issues.
That's correct. That's correct, John. That is.
Assuming that, I'm not saying we're there yet, I'm just thinking it through procedurally.
Sure, absolutely. I understand, and I think we're on the same page there, because I do think if this court were to waive the timely filing of a notice of appeal in the interest of justice, that appeal, that direct appeal, would be limited to sufficiency in sentencing because the original motion for new trial was untimely. Of course, anything he may want to raise under plain error. And then, when that is concluded, assuming he's unsuccessful, I think simply would require the trial court to reactivate essentially the post-conviction that's currently pending, or allow that to be withdrawn and amended or refiled. Yes, Your Honor. I think that's correct. I recognize this is one of the few cases where the state and I agree on just about everything, frankly, Your Honors. Our point in this appeal and in challenging or opposing initially the Rule 9 application, and then once the Rule 9 was granted, filing a responsive brief, our point was simply that we take no issue, obviously, with what the trial court did. Our issue is was with what the state failed to do in the trial court proceedings. And I recognize the Abdurrahman cases and the cases cited in that decision. I would note, I think we're in a little bit different position here, because in those cases, typically it's the local district attorney's office actually affirmatively entering into an agreement that the Attorney General's office then sort of tries to undo on appeal. Here we have the local district attorney's office simply doing nothing for 9 months after that motion for new trial was filed, and then that same district attorney reversing course and seeking the interlocutory appeal in the trial court. And I guess no matter how this case turns out, I would just ask the court to take that into consideration as well, because we have a situation where when that motion for new trial was filed and it was untimely, frankly, I think this is one of the most clear things we have in our law, is that an untimely motion for new trial is void, is a nullity, and the trial court does not have authority to waive that timeliness. That's one of the few things that's very, very clear in our law. I think all of this could have been avoided with the DA's office simply filing a response in opposition to the motion for new trial, quoting all the law that the state and I have argued in our briefs on appeal, and perhaps we wouldn't be here. So our position is simply...
Let me ask you this. So one of the things as you're talking, I was thinking, well, the DA could have thought, well, the trial judge, he's going to get around to dismissing this at some point in time. There's no point in me wasting my time drafting something and filing it, because as you just said, it's one of the most clear things in our law. Okay. And that very easily could have been what they were doing. We don't know. I ask that because would your position be any different if they had filed it? I mean, I think I know the answer to this. If they had filed it and it still took the trial court a year to rule and had followed the law at that time and denied the motion for new trial as being untimely?
Sure, then I think we're not here, right? And I think that's the problem here, is we're here on a Rule 9 interlocutory appeal. If you read the transcript from the motion for interlocutory appeal in the trial court, the state didn't even try to argue the Rule 9 criteria. And so if you really focus on the rule, I know we're past that point now, but if you focus on the Rule 9 criteria, I think you'll see the trial judge here was trying to do what it thought was best in the interest of economy and efficiency, and now we've simply done the opposite.
But I guess, and to kind of further on my question, though, is it's almost as if you're arguing that despite how clear the law is on this, and despite the trial court's duty to act and to rule, and this, that, and the other, that it all rests on the state because they didn't file one piece of paper.
I think it's more than that. I think they didn't file a responsive pleading, and then at both hearings that were held on this, they simply stood silent. And I guess my point is not to, I know the court hasn't made its decision yet, but I do agree that the law is pretty clear here. And so I guess our point is simply that however the result turns out, that the opinion remind the trial court, it's not supposed to do these things, but also remind the district attorney's office that they have a duty to investigate and litigate and do their legal research as well, so that we hopefully avoid these long periods of delay when Rule 9s are supposed to do exactly the opposite. So we would respectfully ask the court, if it does decide that the trial court's order is void for lack of jurisdiction, again, to note that Mr. Banner still has the opportunity to pursue other available remedies in consultation with his trial counsel. Thank you, Your Honors.
Thank you. Gross?
Yes, just briefly. Respectfully, I do think we need a little bit more than a reminder. I think we need a reversal here. We can't allow trial courts to circumvent the post-conviction procedure process by exceeding their jurisdiction and granting a new trial. To short-circuit that process, we need to go through the proper channels. I do agree there are other procedures, such as a late filed notice of appeal, although, again, all issues other than sentencing and sufficiency would be waived. If there's no further questions, though, we respectfully ask this court to reverse the order granting the defendant a new trial and to reinstate the original judgments. Thank you.
All right, anything else, Madam Clerk? All right, we'll be adjourned until May.
All right.